the laws that are made by the British people, there are only two laws that are made by the British, which are made in 1872, are considered to be the best legislations, because even after the passage of 150 years, approximately 150, 60 years, these are the two legislations that were not made many changes in the particular enactment, any amendments in the particular enactment. And these two are, one is the Contract Act, the other one is the Indian Evidence Act. And I hope the students will be benefited by the great knowledge of our Professor V. Kesava Rao sir, who also edited Woodruff and Amir Ali book, 17th edition of the book, which was made by sir. And I hope that the students will enjoy his lecture, right from MP locals to all over India who are watching this particular thing through Zoom link and also through YouTube. Thank you, one and all. Mihir.
Thank you, sir. Since I've been given this opportunity, I would like to say a few words about our resource person for today, Dr. V. Kesava Rao, sir. Sir is currently working as a... Dr. V. Kesava Rao, sir, is currently working as a Vice Chancellor at NUSRL, Ranchi, Jharkhand. Sir has held countless prestigious positions like the Chairman of Academic Coordination Committee, Director at Center for Distant Examination, Chief Warden, all at NLUO, Cuttack, Odisha. Sir has also been served as a registrar at CNLU, Patna. He has also served as a principal of Law College in Andhra University. Sir completed his BCom, LLB, LLM, and PhD, all along with gold medals as best performing student and scholar, respectively. Sir has been awarded numerous prestigious awards like Justice E. Venkatesham Prize, Law College Decennial Celebration Prize, N.S. Subba Rao Memorial Prize, and many more. Sir has also authored many research papers which were subsequently published in renowned journals. Sir has been a part of legal and management development programs for senior managers of corporates and senior government officers. Sir has had over 3 decades of teaching experience. We are truly honored to have you here with us today. I'm sure that we all are very excited to learn from Sir. But before I do, there is a small instruction for our attendees. There will be a Q&A session at the end of today's program. So I request all the attendees to leave their questions in the Zoom chat box or in the live chat section of the YouTube video. With all this being said, I now request our resource person for today, Dr. V. Kesava Rao, sir, to kindly enlighten us. Over to you, sir.
How to share the PowerPoint presentation?
Sir, there is a share screen is there in green. You'll find in taskbar. There is a share screen option is there.
Yeah.
Yes, here. Share screen green color.
Yeah, we did that.
Yes, sir. Your slide is visible, sir. And sir, there is an option. Sir, there is an option here. You can put it slideshow. Yes, sir. Thank you, sir.
It is visible now?
Oh, yes, sir.
Am I audible?
Yes, sir.
Okay. Very good evening, Dr. C.M. Rao, the principal of MP Law College, Aurangabad, and dear students and others who are participating in the program. Well, I am asked to make a small presentation. And the topic that is given to me is Overview of Indian Evidence Act. In fact, it would be correct to say that I have chosen the topic, an overview of law of evidence. Friends, whenever you witness a court session, either in a movie or physically, most of the time at the trial level is not spent on arguments, but it is spent on admitting evidence or not admitting evidence. How to operate this? Okay. So friends, I welcome all of you to this overview of law of evidence which is contained in the Indian Evidence Act of 1872. We all know that aim of law is always to do justice. And when negotiation, conciliation, mediation, and arbitration fail, there is only one method for ensuring that justice is done, that is by adjudication. And adjudication is always done by a judge, because the judge will have to know the truth to ascertain and to do justice. Truth depends on facts. Therefore, the court is concerned with either the existence or non-existence of facts. Once the court knows whether certain facts exist or do not exist, the court will know the truth, the judge will know the truth, and the judge will be able to do justice in accordance with law. Therefore, facts are the most important concern for the judge. But how to find out what is the truth? Facts leads the judge to the truth. Well, please see the picture which is there. On the one side there is a plaintiff, on the other side there is a defendant, and there is a litigation going on. And who is milking the litigation cow? It is a lawyer under the careful observation of judge. Now, who will win? Is it the plaintiff or the defendant? Depends upon on whose side lies the truth. And truth can be known only when the judge knows what are the facts. Therefore, in a trial court, always the main aim is to ascertain the facts. Once the facts are ascertained, justice can definitely be done without any problem. Next. That is why we all know that in any litigated manner there are two basic components. One, the facts, the other, law. Law is applied to facts by the judge. Therefore, the question arises, what are the facts in this case? Facts are to be ascertained. Truth has to be established. Now, if truth has to be established, who has to establish the truth? What are the means available? Let me place before you some wonderful means that were adopted at one time or other for ascertaining what is the truth. One is called the battle method. Another is the hot iron rod method. Third one is the boiling water method. Fourth one is the corpse touch method. Fifth one is tie and throw method. And last but not the least, is the torture method. These methods are barbaric, inhuman, irrational, and illogical. But unfortunately, at one time or other in the history of the civilization, these methods have been used for finding out the truth and thus the facts. So next. The first one is the battle method. Let the two parties who are in litigation, who have a dispute, fight with each other. Well, we know pretty well when a fight takes place between two people, what happens is the might will prevail over the other. The mighty stands a chance of proving to the court that whatever he says is the truth. Because the belief is divinity would take the side of the right. But we know pretty well in a battle, it is the might that wins and not the right. But let us be conscious of the simple fact that this was a method that was used at one time or other in the history of civilization. Next. Hot iron method. Hot burning iron rod is placed, and mostly in criminal cases, the accused is asked to touch it, hold it for that matter, on the presumption that innocent person would not be burned. Well, I don't know whether you came across or not, but I can assure you that I have never come across a case where a person who holds a burning rod doesn't get burned. But yet, this was a method. Similarly, next. The third method was called the boiling water method. The person that is accused of guilt, this is also a method that was adopted in criminal trials. The person that is accused of committing an offense or a crime is asked to dip his hand in hot boiling water. And if nothing happens to the hand, he is innocent. If something happens to the hand, he is guilty. We know, they say, only guilty person will be scalded. But when hand is dipped in hot boiling water, well, I'm sure it never asks for the simple question whether the hand is that of a guilty person or an innocent person, but it will undoubtedly be scalded. Yet this was a method sometimes adopted in criminal trials. The fourth method, that is a corpse touch. That means the person that is accused of anything, especially an offense or a crime, commission of an offense or a crime, is called upon to touch a corpse, a dead body. The belief was corpse will show some reaction if touched by innocent person, and corpse will not show any reaction if touched well. If it can show some reaction, it can never be called a corpse, and if it is a corpse, it can never show any reaction. But unfortunately, this was the belief at one time, because they felt that divinity will always stand by the side of innocent person, and he will speak through the movement of the corpse. But we know pretty well it is illogical, it is irrational, yet this method was the fourth important method that was used to find out on whose side is the truth. As if this is not enough, next one. Tie and throw. This is a beautiful method adopted whenever somebody was accused of being a witchcraft or practicing witchcraft, being a witch and practicing witchcraft. What they used to do was they tie the legs and the hands of the person that is accused of witchcraft, and from a bridge, the person is thrown into water, let's say a river, and if the person is innocent, they will float. I don't know how a person that can float if the feet and the hands are tied, but the belief is the divine or the God will stand in favor of the innocent persons, and therefore innocent person will not die, he will not drown into the sea or water or river, and he will float. Thus, he is exhibiting the truth on his side. But we know pretty well when a person can't swim, he has no option but to drown. Thus, he proves himself to be guilty. This is how truth was ascertained, these methods. And the latest, next one, sir, is the torture. We know pretty well it is known as the third degree methods, and third degree methods are also being used only for the purpose of finding out what is the truth. Well, this is the modern practice. Unfortunately, these methods were adopted. They are not being adopted now, but they were adopted at one time in the quest for truth, in the quest for finding out what are the facts. If truth is known, justice can be done was the simple statement that was believed, propagated, practiced, and promoted by people at that time. Now, these are barbaric, irrational, illogical, inhuman. Therefore, they are not in use except the last one, where sometimes we are hearing in papers that this method is also being adopted. No, friends, how to establish the truth if we don't want to follow these inhuman, barbaric, illogical, and irrational methods? There are two different ways in which the truth can be placed before the court. The judge can be made knowledgeable of the truth. One is parties to prove the facts. The other is judges to find out the facts. These two methods, one is called parties to prove the facts, which is part of the adversarial system of law and justice. And the judge himself has to find out what are the facts and therefore the truth. It is called inquisitorial or inquisitorial system of law and justice. This is very sophisticated method, humanistic method, rational method, and undoubtedly it is logically supported. Therefore, nowadays, the countries, most of the nations, either follow the adversarial method or inquisitorial method. India, having inherited the legal system from British, we follow the adversarial system. The crux of adversarial system is it is not the duty of the judge to find out what is the truth. It is not the duty of the judge to find out what are the facts. Any party that adverts that these are the facts must prove that those facts exist. Anyone that can prove that the facts exist will win the case. Party that cannot prove that the facts exist will lose the case. That is why it is called adversarial. Any party that adverts to certain facts has to prove it. It is also called accusatorial system of justice. Anyone who accuses will have to prove the truth of the accusation. He has to bring facts which establish the truth of the accusation he makes. We are following that system. We are not adopting the inquisitorial system. Our judge is not expected to find out what is the truth on his own. Our judge is expected to find out what is the truth by simply focusing his attention on the information placed before him by the parties. It is the parties to prove the facts. Thus, parties prove the truth. Therefore, friends, remember, parties that can prove the facts will win the case. Parties that cannot prove the facts will lose the case. I may tell you here, when one party goes to a court of law, it tells the court that he is speaking truth, only truth, and nothing but truth. He is, I may be permitted to say, he tells the court that I am Satya Harishchandra and I speak truth. Therefore, whatever I say is the truth. And the other party doesn't keep quiet. He says, I speak truth. Whatever I say is only truth. And I speak nothing but truth only. He says, I am the father of Satya Harishchandra. When both parties are claiming that what they say is the truth, the court has to find out what is the truth, not by making any independent inquiry, but by calling upon the parties to prove the truth of the statements they make, to prove the truth of the facts which they accept. This is the simple thing they are expected to do. In adversarial system, whoever says it is the truth, he adverts to the fact. Therefore, he has to prove it on the simple premise. Entire law of evidence is based upon one simple sentence. Proof. Truth is always capable of proof. I repeat, truth is always capable of proof. Facts are always capable of proof. If a person says that these are the facts, yet he is unable to prove it, it means whatever he claims to be facts are not facts at all. If a party says that these are the facts and fails to prove it, then he has to face the consequences, because facts are always capable of proof. If you are incapable of proving, you are not relying upon facts. What you are claiming are not facts. What you are accepting are not facts, and therefore the truth doesn't stand on your side. Therefore, justice will not be on your side. Hence, you are bound to lose the case. Remember, in India, cases are won if there are facts on your side. If you can prove that the facts are on your side, and the case is lost if the facts are not on your side. If you fail to prove that the facts are on your side. This is the essence of the adversarial system in which we are operating. Having inherited from the common law is totally based on adversarial system, and our adversarial system also says facts are capable of proof. If you can't prove it, that means what you are telling are not facts. Next. In the adversarial process, we start with always human interaction. Let us say one person gave 1,000 rupees by way of loan to other party. Plaintiff has given 1,000 rupees to the defendant. Now, when loan is given, the defendant is under a statutory duty. Law says he has to pay because he executed a promissory note. He made a promise that he will return the 1,000 rupees given to him. Well, if he were to return, then there is no problem, happy ending. But if he doesn't return, then there is a plaintiff asking for money and the defendant not giving the money taken. Therefore, there is a dispute. And the civilized way of settling a dispute is by filing a case. And we go to court. A government created and established institution for settlement of disputes and file a case. And mere filing of a case is not enough. The case has to be proved. This is where filing a case means the plaintiff is telling, it is a fact that I gave money to the defendant. It is a fact that the other party executed the promissory note. It is a fact that the defendant has not repaid the money to me, despite several times requesting me. Hence, I have no option but to come to you. Hence, I am coming to you by filing this case. He states the story, the facts in the plaint. He is called the plaintiff and the document submitted by him is called the plaint. Then, mere statement that I have given money, other fellow wrote the promissory note and it did not repay the money is not enough. Because we depend on proof. Therefore, the next stage is proving the case. After the facts are proved, that means the plaintiff has to prove that he gave money. Plaintiff has to prove, number two, defendant executed the promissory note. Plaintiff has to prove, number three, that the defendant did not pay. Once the facts are proved, the application of law. What does the law say? Anyone who takes loan by making a promise, by entering into a contract to repay, he is bound to repay. Therefore, facts are in favor of the plaintiff, law is in favor of the plaintiff, and decision is given by the court. Defendant has to pay 1,000 rupees with interest and expenses to the plaintiff. But what is the mere use of the decision, which is something written on a piece of paper? No party would be happy by simply getting a decision in his favor. He will be happy only when the 1,000 rupees that went out from his pocket comes back into his pocket. That is called implementation. Now, this is in the simple language, but we lawyers are expected to use some technical language. So, technical language, there is a transaction between the plaintiff and the defendant. What is the transaction? Giving a loan of 1,000 rupees. The transaction led to cause of action. What is the cause of action? Non-repayment of 1,000 rupees by the defendant to the plaintiff. Therefore, there is a cause. Non-repayment is a cause for the action that is filing the case. Therefore, the next stage, third important stage, is the institution of proceedings. Case has been filed in a civil case by filing a plaint by the plaintiff against the defendant for recovery of money. And then comes the most important stage, demonstration of proof. This is where evidence is brought by the parties in support of their claims. The plaintiff brings evidence in support of his claim that he gave 1,000 rupees to the defendant. The defendant has executed the promissory note and the defendant did not pay the 1,000 rupees back. Now, what does the defendant do? Defendant may say, I have repaid the money, I have not received the money, I have not executed the promissory note, I have paid part of it, I am not bound to pay, or I am not due to pay the entire amount. Then comes argumentation. Both parties will say how the legal principle can be applied to the concrete set of facts, and then court gives the judgment and then execution. If you count, the entire process consists of 7 important stages. I would say that this is the Saptapadi of adversarial process. Saptapadi is 7 steps we take. Similarly, in adversarial process, for any dispute to come to an end, there are 7 important steps, starting with the transaction, ending with the execution. The transaction is 1,000 rupees given. Cause of action is non-repayment of 1,000 rupees. Institution of proceeding is filing a civil case. Demonstration of proof, both parties bringing evidence in support of their claim. Argument, application of law to the facts. Judgment, delivered by the court to render justice, and in accordance with the judgment will be implemented, that is execution. This is the Saptapadi. And the most important stage, basing upon which the case may be won, may be lost, is the 4th one. Proving the case or demonstration by proof. It is that stage that is very important, because that stage determines whether you will win or not, whether truth is on your side or not, whether you have succeeded in proving the facts or did not succeed in proving the facts. This is the most important stage. This can be compared with a jigsaw, a child's play. On the one side, there is a transaction, cause of action, and institution. On the other side, there is argumentation, judgment, and execution. But please remember, there is a center stand. It is a stand that is proof by evidence. Because that jigsaw bench will tilt in favor of the party who has proof. And the party that doesn't prove, that cannot prove, will be lifted up, in the sense they will be losing the case. And justice will be sitting in favor of the party on whose side there is proof. Therefore, friends, dear students, please remember, in adversarial system or in accusatorial system like ours, what is important after filing the case to win the case is proof, and proof of facts. Proof of facts is always placed before the court by means of evidence. This is where, for the first time, the word evidence comes into picture, because evidence proves facts. Facts establishes truth, and truth will enable the judge to render justice. That justice depends on evidence. Party that can prove evidence and thereby the facts will get case in his favor. Party that fails to prove by bringing evidence to court will lose the case, and he has to be content by feeling that justice is not in his favor because he was unable to prove that his claim is truthful. Like this jigsaw puzzle, whoever has the proof will be winning the case. That is the essence of this adversarial system. And to prove the facts, what is important is evidence. Without evidence, no fact can ever be proved. And friends, this is the crux of the entire necessity of evidence. Why evidence? See, court is interested in ascertaining whether the facts as accepted by the parties are existing or non-existing. If they are existing, they are proved in the court by parties by bringing evidence. Without evidence, no case can ever be won. Letting in evidence is regulated by law. What can be brought as evidence, what cannot be brought as evidence, there must be some rules or other. It is in accordance with those rules only evidence can be brought before the court. Therefore, letting in evidence, that is bringing evidence to a court of law, is always regulated by law. And we have to be careful about the bringing of evidence into a court of law. Hence, without evidence, case is lost. With evidence, case is won. When you go to a court of law and file a case, especially you, the law students, when you become lawyers, clients come to you, they have a dispute, they approach you, and you file a case. When you file a case on behalf of your client, he may be the plaintiff or the defendant in a civil case. He may be the prosecutor. If you may be the prosecutor, or you may be taking up the case of an accused person in a criminal case. Or in a private complaint, you may be taking up the case of a complainant, or you may be defending an accused person. Or in some civil cases, like divorce, you may be appearing for the petitioner, or you may be appearing for the respondent. In all these cases, case is a set of facts. Those facts must be placed before the court by means of evidence. Therefore, the job of an advocate is to see what evidence is available. He has to preserve that evidence and he has to present it before a court of law. That is why in adversarial system, cases are won if there is evidence, cases are lost if there is no evidence. Because evidence proves the facts and leads to the establishment of truth. Judge will know the truth and judge will be able to do justice. Thus, proof is necessary and proof of facts is necessary, and proof is always placed before the court by means of evidence. That is why the first important question we should ask is why evidence, and the answer we should all know even before we venture to understand the law relating to evidence. Why evidence at all? Without evidence, no facts can be proved. Without proof of facts, no truth can be known. And if truth can't be known, there is no question of any justice being done. Therefore, the job of an advocate is to preserve evidence and then present it in a systematic manner before the court. Well, this leads us to some questions. Number one, why evidence? Number two, what is evidence and what is not evidence? Number three, who should bring evidence? Number four, on what matters evidence can be brought? Can we bring evidence on any matter that is totally unconnected with the dispute? Number five, by what methods evidence can be presented before the court? And lastly, what is order? That is how evidence can be presented before the court. Remember, friends, for understanding any subject in a systematic way, you must remember one small equation. That equation is 5 W's and 1 H. 5 words starting with W and 1 word starting with H. If you remember it, any subject, you will be able to understand. What are those 5 words? Why, who, what, when, where, and how. Similarly, the best way to understand law of evidence is by asking a few questions. Question number 1, why evidence? Question number 2, what is evidence? Question number 3, who should bring evidence? Question number 4, by what methods evidence can be brought? Question number 5, on what matters evidence can be brought? And question number 6, how evidence must be presented to the court. Answers to these 6 questions put together. Let me repeat. Answers to these 6 questions. Why evidence? Who has to bring evidence? What is evidence? On what matters can evidence be brought? By what methods can evidence be brought? And how evidence must be presented before the court? Answer to these 6 questions put together is simply called law of evidence. For each of these questions, there are answers. All those answers are brought together and they are given a beautiful name, law of evidence. Because without evidence, you can never win the case. And always evidence is brought before the court in accordance with certain principles. And that last sentence on the screen, letting in evidence is regulated by law, and the law that regulates the letting in of evidence is the law of evidence, which in India is contained in Indian Evidence Act of 1872. In other words, Indian Evidence Act of 1872 provides us answers to 5 questions. Very simple. First, it tells us what is evidence and what is not evidence. Second, it tells us who should bring evidence. At what point of time who should bring evidence. Third, on what matters evidence can be brought and need not be brought and cannot be brought. Fourth, by what methods evidence can be brought before the court. And lastly, the 5th question, how evidence must be presented to the court. Of course, remember the basic question, why evidence, we have already covered. Because we have understood why evidence is necessary, why law of evidence is necessary, let us remember that basically law of evidence answers 5 different questions. Number 1, what is evidence? Number 2, who should bring evidence? Number 3, on what matters evidence can be brought? Number 4, by what methods evidence can be brought? By what means evidence can be brought? And lastly, number 5, how evidence must be presented before the court. A set of principles are there. All the principles put together is given a simple name, a beautiful name, law of evidence. Thus, law of evidence answers these questions. And in India, law of evidence is to be found in the Indian Evidence Act. So friends, basically, we are concerned with these questions. What is evidence? Why evidence? What is evidence? Who should bring evidence? On what matters? By what methods? And how it must be presented before the court. Now, let me present to you how Indian Evidence Act treats with these 5 different questions. So we have to go to, okay, go to the next one. What is evidence? I told you what is evidence is the first question. Who should bring evidence is the second question. On what matters evidence can be brought, cannot be brought, and need not be brought. By what methods evidence is brought and how evidence is presented before the court. Now let us see. As a matter of fact, if you look at the Bail Act, you will find entire Indian Evidence Act is contained in sections 1 to 167. It has 167 sections. What is evidence is answered in section 3 and 4, normally known as the interpretation clause. Who should bring evidence is answered in sections 101 to 114. All principles answering the question, governing the answer to the question, who should bring evidence, are contained in sections 101 to 114. On what matters evidence can be brought by the parties, cannot be brought by the parties, need not be brought by the parties because the court takes note of them automatically. They are given in the sections that are presented before you on the screen. By what methods evidence is brought? We know pretty well that any court has only two doors. Any evidence will enter into the court only through these two doors. The name of one door is oral evidence. The name of the other door is documentary evidence. And how evidence is presented before the court, the last part of Indian Evidence Act, 135 to 167. Those of you that carefully observe, Section 1 tells the name of the statute and its territorial application, that is, it's applicable to all of India, except Jammu and Kashmir up to one time. Now, because of the special position that is accorded to it last year or 2 years back, now it is extended to whole of India. So, definition of evidence is contained in 3 and 4. You must be wondering what happened to Section 2. Section 2 was repealed. So, Section 1 tells the title and the application. No problem. Section 2 is not there. Therefore, our inquiry must be between sections 3 and 167. 3 and 4, they deal with evidence. Observe carefully the screen. After 4 comes 5. 5 to 55, it specifies one of the most important chapters in the Indian Evidence Act, on what matters evidence can be brought. The simple answer is, on every relevant matter evidence can be brought. But what are the relevant matters? That is answered in sections 5 to 55. Then 56 to 58 tell us on what matters evidence need not be brought. 59 and 60 deal with the means called oral evidence, and 118 to 134 deal with when you bring oral evidence through a witness, who is competent and who can be compelled and who cannot be compelled. All that oral evidence, 59 to 60. 61 to 100 deal with the second means of proof, namely documentary evidence. 101 to 114 answer the question, who should bring evidence? And 115 to 117 deal with on what matters parties cannot bring evidence even if they want to bring, because they are stopped from bringing such evidence. 115 to 117. Then oral evidence is continued from section 118 to 134, 135 to 167, how evidence is presented before the court, that is relating to examination of witnesses. Therefore, friends, 3 and 4, 5 to 55, 56 to 58, 59 and 60, 61 to 100, 101 to 114, 115 to 117, 118 to 134, 135 to 167. That is how the total sections of Indian Evidence Act, which number 167, can be comfortably divided and easily remembered, keeping in mind, if I go to section 6, I am going to get answer to the question on what matters evidence can be brought. If I go to 116, I am going to get answer to the question on what matters evidence cannot be brought. If I go to 74, I'll be getting the answer to the question whether this kind of documentary evidence is admissible or not. If I go to 139, 140, 141, I'll be able to know what type of questions I can ask in examination of witnesses. Thus, 5 questions. What is evidence? Who should bring evidence? On what matters evidence can be brought? By what methods evidence can be brought? And how evidence is presented before the court? All this is answered in the Indian Evidence Act, which is the law of evidence in India. Only sections that need not be covered are sections 1 and 2, because 1 is a territorial application of the name of the act, 2 was repealed long back. Therefore, our focus must be from sections 3 to 167. And if you remember this division, even before you start reading any part of the Indian Evidence Act, you will have absolute clarity. By reading this section and understanding the principle enunciated in it, I am going to get clarity on this particular matter. Who should bring evidence? Is it the plaintiff or the defendant? When plaintiff, when defendant? Let me give some examples. In a criminal case, the accused says that I killed the deceased by exercising my right of private defense. It takes up the plea of RPD, right of private defense. Who should prove? When the accuser says that he is entitled to the exceptions, general exceptions contained in the Indian Evidence Act, who should prove? To this question, the answer you will get in section 105, because who should bring evidence on this particular matter is dealt in section 105. Basically, when a case is filed, who should start the case? 101. Who should bring evidence? Any party that would fail, 102. Like this, these sections. One must be clear that from this section to this section, this is the type of question that is answered. From this section to this section, I'm going to get information relating to what kind of document can be taken to the court as evidence, what kind of document cannot be taken to the court as evidence. Who is competent to give evidence? Which human being is competent to give evidence? Who can be compelled to give evidence? Who cannot be compelled to give evidence? So these are answered in sections 118 to 134. If you keep in mind this division, even before you start reading, you know pretty well what is the type of question for which you can expect answer from that section. This is the subdivision of the entire law of evidence. See, on what matters evidence can be brought? On some matters, parties are given the power to bring evidence, can be brought. On some matters, even if parties want to bring evidence, the law does not permit him to bring evidence because they fall under the category cannot be brought. And on some matters, even if parties do not bring any evidence, the court takes it for granted that this fact is true. Need not be brought because the court will take notice called judicial notice. This is how the entire Evidence Act can be subdivided as answers to a few questions. Unfortunately, these questions are not in the same order. It is easy to ask these questions and understand the entire scope of evidence in this order. First question, what is evidence? Second question, who should bring? Third question, on what matters? Fourth question, by what means? And lastly, how it must be actually presented before the court. Once we know that this is order, we generally expect the Indian Evidence Act also to give answer to these questions in that order. Well, unfortunately, Indian Evidence Act, which is based upon English law of evidence, which is not codified, but owes its credit to one person by name Sir James Fitzgerald Stephen. We call him simply Stephen. He is the person that collected the decisions from different cases in England, considered whether those principles enunciated in those cases are suitable to Indian conditions or not, and then made the entire statute. He is the one that is credited with the drafting of the statute, and the greatness is, though it came into force way back in September 1872, and it is going to celebrate 150 years by next year, it is not touched at all. Even on one or two occasions when some amendments have been made, new sections have been brought, but existing sections have more or less been not changed. That is the greatness of the draftsmanship of this statute. Highly technical subject. Some students say most boring subject. But those of you that want to go for practice in a court of law, especially in a trial court, either civil or criminal side, you can never dream of winning a case. In fact, treating a case unless you are aware of the law of evidence. Thus, friends, law of evidence provides answers to basic questions. What is evidence? Immediately, naturally, the corollary is what is not evidence. Who should bring evidence? Can a person bring evidence on any matter? Connected, unconnected with the dispute? What we call the fact in issue? By what means can evidence be brought? Can you bring a 1-year-old boy, child to the court and say he is the witness to a murder trial? Can we bring a person who is senile to the court and say that he is competent to give evidence? Can a judge be compelled to be a witness? These are all the questions like oral evidence. Who is competent to give oral evidence? Who can be compelled and cannot be compelled to give oral evidence? What should be the character of the oral evidence? All this is answered in sections 59 and 60 and 118 to 134. Then documentary evidence. What is a document? How many kinds of documents? Public document, private document, document requiring attestation. All these are dealt. Presumptions as to documents. And if there is an ambiguity in the document, how the ambiguity can be cleared, what kind of ambiguities can be cleared, all this, one of the biggest chapters running into 40 sections, 61 to 100 is documentary evidence. Because most of the times, the cases depend on documentary evidence, including electronic evidence. And we come to on what matters evidence can be brought, sections 5 to 55. Simple answer, as I already said. One party can bring evidence on every relevant matter. Relevant means relevant to the case. But what is relevant and what is not relevant? This has to be understood by reading sections 5 to 55. The concerned teacher of evidence will definitely explain them. But then please understand, when you are reading section 8, which says evidence of motive, character and preparation is admissible, you are understanding that you can bring evidence that shows the character of the party, evidence that shows the motive of the accused to commit the crime, and evidence that indicates the preparation by the accused for commission of a crime. That is how, if you are clear in your mind, even before you venture to read the Indian Evidence Act, by having a broad idea, law of evidence gives answers to these questions. Then your understanding of evidence will be very good, it will be sound, it will be logical, and you will have a rational appreciation of the entire law of evidence. Well, this is how the entire Evidence Act is divided. Most important is what can be brought. 5 to 55. In fact, I would say the sections 5 to 55 constitute 60% of the entire Indian Evidence Act, though they may be only 50 in number, but the importance and their frequent occurrence in a court of law, they being called in for interpretation before a court, well, all that plays a very important part. Now, 5 to 55. Let us forget about law and let us start thinking. Civil case, plaintiff and defendant. Don't you think that the statement made by the parties is undoubtedly connected with the question when the statement relates to the question? If somebody owes me money, you can't expect me to keep quiet. I'll definitely be making the statement, and sometimes, let us say, I said, that fellow has already given money. Now I'm filing a case saying that he has not given money, but earlier I made a statement he already gave the money. Don't you think that this is undoubtedly connected with the issue whether the opposite party has paid the money to me or not. Therefore, friends, statements by parties is undoubtedly evidence. It is connected with the statements by parties connected with the issue, with the question before the court, is undoubtedly relevant. Similarly, what about character of the parties? Normally, court will not allow itself to be influenced by the character of the party's evidence. But yet, undoubtedly, character plays a very important role. And evidence of character of the parties, not outsiders, so the parties themselves, is undoubtedly admissible, if not for finding whether a person did an act or not, at least for assessing what is the consequence of the such an act. In a defamation case, this undoubtedly character of the parties play an important part. See the number of points I'm telling. Number one, statements by parties. Number two, character of the parties. Number three, sometimes it may so happen that a party or someone relating to party who is connected with the dispute made a statement and afterwards passed away or became incapable of giving evidence or his whereabouts are unknown. But his statement plays an important part, therefore it can be brought as evidence, called statements by parties who cannot be brought to the court. Then, if you want to understand a particular issue, small question. Imagine a doctor's example. You go to a doctor and say, I have headache. Well, I'm sure you all had at least witnessed, if you did not have a personal experience. Doctor will never touch your head. He may touch your wrist, hold your wrist and see the pulse. He may use a stethoscope to see the heartbeat. And he may even examine your tongue. But these parts of the body have no problem. Only head has a problem. But yet the doctor doesn't touch the head. He looks at all other things. Because he is trying to understand the source for the headache or the cause for the headache. Similarly, if the judge has to understand the actual issue, the judge's attention must not be confined to the issue only. The parties must be allowed to explain the issue. Therefore, all facts which are connected with the fact in issue are always admissible. What kind of connection is required is stated in sections 5 to 16. 17 onwards, the statement of parties. 32 and 33 deal with statements of persons who cannot be called as witnesses. 33 onwards, statements made under special circumstances. 40 onwards, judgments rendered by the courts on this issue on previous occasions. But then, all these relate to facts. But sometimes, what is the fact is not known. What is the cause of death of a person is unknown. Only a doctor who is a post-mortem expert, a forensic expert, will be able to tell us the cause of death. But even then, it is only his opinion. Please remember, no case can ever be decided by a judge basing upon opinion. Yet, there is no option but to take into account the opinion of persons who are specially skilled. Therefore, expert evidence from 45 to 51. Character of the parties, 52 to 55. Thus, friends, 5 to 55, which deal with the relevancy, also can be split up. Concerned teacher will tell you for easy understanding. Please understand, if huge amount of food is placed before you, you can't eat all that at one time. But piecemeal, you can eat all that if it is not spoiled. If the thing that is placed before you never gets spoiled, then there is no problem. You can eat it piecemeal in installments. Similarly, 5 to 55 can't be understood at one stretch. 5 to 55 had to be subdivided. Number one, statement of parties in civil cases and in criminal cases. Statements made under special circumstances. Character of the parties. Statements of persons who cannot be called as witnesses. Statements or facts connected with the facting issue. And lastly, opinions of specially skilled persons called expert evidence. All this is included in section 5 to 55. From section 5 till 16, facts connected with the facting issue. 17 onwards till 31, statements made by parties both in civil and criminal cases. 32 and 33, statements of persons who cannot be called as witnesses. 34 to 39, statements made under special circumstances. 40 to 44, judgments. 45 to 51, expert opinion. 51 to 55, character of the parties. This is how relevancy is described. You can only bring to the court that evidence which is relevant. Any evidence which cannot be fit into any one of these 51 compartments. 5 to 55, there are 51 sections. Each section is a compartment. Let's imagine. Whatever evidence you bring, it has to be fit into some compartment or the other. And if you can't fit into any of those compartments, then it ceases to be relevant according to Indian Evidence Act. It becomes irrelevant, and irrelevant evidence is not admissible. That means it cannot be taken into the file of the case. It cannot be taken as a record in the case. That means the judge cannot take into account. He cannot consider that evidence at all. Such evidence, because it is not relevant, cannot prove the existence of facts. Please understand the link. Facts on which parties are given power to bring evidence. Facts on which parties are prohibited from bringing evidence, 115 to 117. Facts on which parties are given option either to bring evidence or not to bring evidence, because even if they don't bring evidence, there is no problem. Automatically, the court will deem that the fact is proved by such evidence. This is how the entire relevancy part is to be understood. Please remember, Indian Evidence Act deals only with the relevancy. It does not deal with the reliability. There may be a document, the document may be relevant and therefore it is admissible. Therefore it is placed on the court record. It is there available before the judge, but the judge feels that the document execution is doubtful. Content of the document is doubtful. Then judge will not be able to take it into account, because according to him, the document is not reliable. There may be 10 witnesses that come to the court and say they saw accused killing the deceased. But there may be one 10-year-old boy who comes to the court and say the deceased was not killed by accused, but the deceased was killed by somebody else. Now 10 witnesses on one side, one witness on the other. Who should we believe? Who should be trusted? Who should be relied? Answer to this question is never given in Indian Evidence Act. It is left to the judicious wisdom of the judge. The judge can say, I don't believe in these 10 people. According to me, they are unreliable. Therefore, I discard that evidence. He may say, this one witness, sole witness, single witness, according to me spoke the truth. According to me, he is trustworthy and reliable. Therefore, I consider only this evidence and I acquit the accused. Or vice versa. He may say, I believe that these 10 witnesses are trustworthy and reliable. Therefore, basing on that, I'll convict the accused. And this one witness, the 10-year-old witness, is not speaking the truth, therefore not reliable. Therefore, I am not taking his evidence into account, and therefore I will not acquit the accused. Reliability of statements made by witnesses in a court of law, reliability of the document that is presented before a court of law is never dealt in the Indian Evidence Act. It is left to the judicious wisdom of the judge. Let me give you a simple example. I have come to Aurangabad and your principal Manikyal Rao invited me for dinner. Well, he made a sumptuous dinner, 15 different items. I am a person who doesn't like sweet because I'm having diabetes. I left all sweets. I am a person who is suffering from, let us say, some ulcer. Therefore, all hot items I left out. I don't drink cool drink. I left out. On that day, it is a Thursday, Shirdi Sai Baba day. I don't take meal at all. Unfortunately, our principal doesn't know I don't take a meal. Therefore, I don't take a meal at all. Several items he has placed, I won't take. I may simply take one glass of water, thank him, and go away. Every item prepared by him is definitely relevant for human consumption. But for me, on that day, they are not fit. Only one glass of water. I take that and go away. Or I may take one fruit and one glass of water and I go away. Similarly, he may say that he will rely only upon this evidence and doesn't rely upon the other evidence. So please remember, friends, never allow you to be misjudged and misguided. Indian Evidence Act only deals with what evidence can be presented before the court. It never answers the question whether every evidence presented before the court has to be accepted by the court. It is left to the judicious wisdom and discretion of the judge. That is why the chapter's heading is relevancy. It is never reliability. Reliability is not touched by Indian Evidence Act. Accepting reliability, the rest of the Indian Evidence Act only deals with these 5 questions, and that is how the section division can be done. Remember this and study in a systematic way, but I am sure there is no subject more fascinating than Indian Evidence Act. Well, this is a short overview of the entire Indian Evidence Act I am presenting before you. I thank the principal, Dr. Manikyal Rao, for giving me this opportunity and to share this information with you. I hope that it will make you a little bit more knowledgeable about the Indian Evidence Act. From P. Jaiswal to everyone, very nicely explained, sir. Thank you very much. Knowledgeable information, accused should prove. From Hakeswara, yes, to everyone, should accused prove? The accused need not prove because accused is presumed to be innocent till the contrary is proved. Now, Satyanarayana Kanakala to everyone, sir. How is evidence fabricated? How it becomes doubtful? Please give a small illustration. How is evidence fabricated? Well, fabrication is creation. Where there is no evidence, you create. You bring somebody, you tutor him, you train him in such a way that even though he doesn't know the fact, he will go to the court and say, this is the fact. That is a fabrication. You take the signature or a document, take a photocopy of it, implant the photocopy on another document and say, this is the document signed by somebody else. That is fabrication. Thanks a lot, Sarji, for your information and nicely explain all that. Okay. Any questions? Okay. Thank you is okay. I am also beholden to you for thanks. But then any specific questions, you are at liberty. Mind-blowing lecture. Well, the mind, I don't know. Then analogy very useful in understanding the evidence. Okay. Thank you, sir. Nice explain. Thank you so much. ना भैया थैंक्स बोलने की जरूरत नहीं है, कुछ सवाल है तो पूछिए. So the Sushant Ring Rajput case, as per evidence point of view, well, I have not seen the evidence at all. Unless you go through the evidence that is presented before the court, we will not be able to say. And these celebrity cases, be very careful. Don't form an opinion about them unless you actually have access to the documentary and other evidence that is presented. You have to go through them. Then only you will be able to say whether it is a fabricated evidence or a real, true evidence. Please give your opinion about the Sushant Singh Rajput case as per evidence point of view. Well, evidence point of view, unless you know what all has been presented, we will not be able to say. And honestly, I'm telling, I had no access to that evidence presented. Once I have the access, Ravindra Vishnath Puriji, I will definitely tell you through Manikyal Rao my evidence, my opinion. Could you please explain the concept of decoy and chance witness? Decoy means he is a person deliberately planted there. His identity is different. He doesn't disclose identity. He mixes with the crowd and then he comes out and says, this is the evidence. Chance witness is a person who by chance he is there. Not by design, but by accident he is there. If a judge sees a crime happening, then can he be a witness? If a judge sees a crime like any other person, then he can be called as a witness. No doubt about that. You please refer to section 120 and 121, 119, you will come across that. Sir, please explain the concept and reliability of electronic evidence that require at least 2 different sessions. If time comes, I will see, otherwise your teacher will tell you. What is evidence can be answered, what is evidence in one line? Okay, evidence is that which makes a person win the case. Absence of evidence is that which makes a person loses the case. That's all. That is the best one sentence I can explain to you. Reliability, identity of forged document. How to identify forged document? Well, so far I have never tried, nor my signature was ever forged. Therefore, I am sorry to say I am not in a position to answer your question. Hanakala, really enlightened, sir. Thank you very much. Advocate Santosh, classmate to everyone. Okay, Sarji, thank you very much. Thank you. What is meaning of leading question? Leading question is a question which suggests the answer that is expected. What is the shirt you are wearing is different from, are you wearing a white shirt? You are doubtful whether he says that he is wearing a white shirt or not. He may say, I am wearing a cream shirt. You don't want to take care of it. They don't want to take any chance. Therefore, you will say, what are you wearing a white shirt? That answer expected from the witness is suggested in the question itself. That is leading question. How many leading questions can be asked? Leading question cannot be asked in chief examination, but leading question can be asked. Leading questions can be asked in cross-examination. To the best of my knowledge and belief, there is no limitation.
Thank you, sir. Thank you very much. Professor Dinesh Kulte, sir, are there any questions on the YouTube side?
No, I think there are no questions. With the permit, yes.
So
there are questions from the chat box of the YouTube, from this. There is a question from the witness that Vankar Vidya. If the judge gives witness in that same case, can he act as a court?
No.
Sir, I hope he studied the administrative law. There is a yes, sir. Sir, please answer this question.
No, he cannot act as a court if he gives a witness because he is biased.
Because there is a saying in admission law, no man shall be judged in his own cause.
No one shall be a judge in his own
His own
case.
cause. Yes. Then,
And
yes,
any
I
other
have-
question?
sir, you answer all the question. Now there are no questions.
Go ahead. Close.
Yes, sir.
Thank you, sir.
Mihir, go ahead.
Thank you, sir. Your words have really enlightened us. I now request Professor Dinesh Kolte, sir, coordinator of this lecture series, to kindly propose a vote of thanks. Over
Thank
to
you.
you, sir.
Thank you. Before that, there is one announcement to all the participants. When you put the question, please put the question relevant to the lectures. Because one question was put here that tomorrow we are going to organize a lecture on there is a dying declaration. Therefore, the relevant question must be
Which dying declaration is admissible in evidence? I don't know what is it you wanted to ask, but I can definitely tell you if it is a dying declaration according to section 32 clause 1, it is admissible.
Thank you, sir.
Go ahead.
It gives me good afternoon to all. It gives me immense pleasure to propose a vote of thanks of today's first session. At the very outset, I express my deepest sense of gratitude to today's honorable speaker, guest, Shri Professor Dr. Kesava Rao sir, Vice Chancellor, National Law University, Ranchi, Jharkhand, who enlightened us on the important topic, and he delivered us the night's presentation on the topic of outline of the Indian Evidence Act. Definitely, we benefited it. We highly obliged to you, sir. I would like to heartfelt thanks to the participants throughout India, the teachers from all the various law colleges, the principals, advocates, the students, they participate today. I express my thanks to them. Special
Can
thanks
I
to my...
answer this question?
Yes,
Can I
sir.
answer which dying declaration is admissible in evidence? Shall I answer?
Okay, go
Only
ahead.
one sentence I'll answer, nothing more than that.
Go
If you
ahead.
permit me, I'll answer.
Go ahead.
Yes, sir.
Dying declaration which indicates the cause of death or what? Circumstances of the transaction that resulted in his death. It need not clearly indicate the cause of death. But if it explains the circumstances in which the death has taken place, both such statements, statement showing cause of death, statement explaining the circumstances of the transaction that resulted in the death, both are admissible under section 32 clause 1. Thank you.
Thank you, sir. I express my special thanks to Mihir Karnik, who anchored today's sessions, and Shubham Jaiswal, who assisted us for his technical support. Once again, I express my thanks to today's guest and all the participants and my principals. Thank you.
Namaskar.
Thank you.
I'll be leaving, okay?
Yes, sir.
Thank you.
Thank you.
Thank you, Master. Untam, sir.
Okay, namaskaram.
Untam, sir.
Thank you very much for the opportunity.
Are sir, wonderful, sir. Chala bon. Chala, thank you.
Thank you. Thank you. Namaskar.
Thank you, sir. I would just like to make a small announcement for attendees. Tomorrow, we will be having a session on evidentiary value of dying declaration by Dr. Anju Sinha ma'am. So I request all the attendees to join us tomorrow as well. With this, I take your leave and I formally conclude today's session.